All right, we will go ahead and get started. So thank you, friends and colleagues, for joining us in this session. I know it's early for some, late for others, including on our panel, and also just right for some some lucky ones, including myself. So we have a really terrific group here with us to talk about this issue of crippling compensation. I think this highlights the timeliness and importance of the issue, and also, of course, the caliber of our speakers. So we will get started right away. We're going to start with a brief introduction by Martins of his work and the issues raised in it. And for your reference after the event, I'll put a link in the chat to the place where you can find the paper, and you can take a look at that after the discussion. And then after Martins gives us an overview, we'll hear from our expert commentators that we are honored and grateful to have with us here. So we have Jonathan Bonniccia, Senior Lecturer in Law at the University of New South Wales, Rodrigo Monardes, who's Undersecretary for International Economic Relations with the Government of Chile, Virenz Mascarenas, Partner at King & Spalding, Christina Bahari with Foley Hoag, Counsel of Foley Hoag, and John Daly, who is Deputy Assistant and Legal Advisor on International Claims and Investment Disputes with the U.S. Department of State. And I'm Lisa Johnson. I am the Head of Investment Law and Policy here at the Columbia Center on Sustainable Investment. Now, as you'll note, all of our speakers have different roles and work and likely different perspectives as individuals. So we look forward to their insights and the back and forth that we're hoping that they generate. We'll do our first round of audience questions and comments after about 25 minutes. So please just start entering them in the Q&A field as they come to you, and we will do our best to take as many as we can. So with that brief intro, let's turn over to the meat of the discussion. So Martins, we will start with you. Go ahead. Thanks.
Well, many thanks, Liz, and many thanks to speakers for braving very early and very late hours. That is really greatly appreciated. As Liz said, I will first give a brief, as it were, précis of my argument. It will really be rather brief because I'll have an opportunity to return to it multiple times. In a very old-fashioned way, I even have a paper copy of the journal here, the last November's issue of Modern Law Review, where the paper was published. Let me just be very brief at this point and make 3 points. First, what is the paper about? And I wrote the paper really, spurred by one particular development, the rendering of the $8 billion+ award by the ConocoPhillips and Venezuela Tribunal in March 2019, one day after the IMF published a note describing Venezuela's catastrophically unique economic circumstances. The question that struck me is whether these circumstances are in any way legally relevant for determination of quantum of content of responsibility for Venezuela in investment arbitration setting. So that is the question, not a question about merits or jurisdiction or valuation as such, but a different perspective, the question of whether the capacity of the state to simultaneously satisfy its international obligations under an arbitral investment treaty and to provide basic public goods to its peoples is somehow legally stick together. So that is the question. And in the paper, I take a rather deep dive into applicable rules, which seem to me to be mainly constituted by customary law of state responsibility, secondary rules on the matter, mostly customary to the extent, of course, that they are not provided otherwise in treaties, which I don't believe that they often are on this particular topic. What does custom tells us on this? And I think the starting point here is the principle of full reparation, going back to times immemorial, or at least the 1920s, endorsed deeply and widely and calling for full reparation for the wrongful act in a manner that focuses exclusively on the perspective of the injured actor and does not obviously include as legally relevant the capacity of the responsible one. And the leading document on the topic is, of course, the 2001 International Law Commission articles on responsibility of states for internationally wrongful acts that engage directly with this issue. The last special rapporteur, now Judge James Crawford, considered the question of whether the capacity of the state could be relevant for determining compensation, and Judge Crawford concluded in negative terms. He felt in 2000 that mostly compensation awards against states were relatively trivial in amount. To the extent that they were large, one could rely on states to be wise and enlightened and not to push such claims. So the backdrop for him was Versailles and Keynes' economic consequence of peace. To the extent that the claims are pushed, we can rely on international institutions, but to include certain limiting factors. Again, the background is United Nations Compensation Commission and limitations for Iraq and its foundational rules, and if all else fails, then we have circumstances precluding wrongfulness. And I think those arguments seem perhaps slightly less persuasive in investor-state arbitration in 2021, where very significant claims are fairly routinely made. If we check the indispensable investment arbitration reporter, virtually every week we have a news item of a multi-billion claim being launched, defended, set aside, reversed, and so on. And because they are non-state actors, they are not repeat players and therefore not inclined to engage in the type of system-preserving generosity that Crawford had in mind. And circumstances precluding wrongfulness have had, let's say, not a very effective record of invocation. At the same time, and that is my perhaps slightly contrarian point, even the policy underpinnings have shifted. As a matter of law, states have not challenged the principle in individual cases, and that seems to me, for the purposes of custom making, count as a legally relevant silence. What the International Law Commission described in its 2018 conclusions on custom as a silence where a reaction would be called for. So the policy assumptions seem less persuasive, but as a matter of law, states seem to have broadly accepted the position stated in International Law Commission's articles that the capacity of state is not legally relevant for this point. So where does that leave us? And it seems to me that it leaves us with broadly four possible responses. One is that this is not a problem at all, and that was the approach taken by the authority of the 9th edition of Oppenheim. If a state cannot pay and cannot borrow to pay, this is a point that has to be taken into account for the negotiated solution. So quantum is simply a point of paper that reasonable people will eventually negotiate down to something. And there certainly have been a number of negotiated solutions in these very large claims. Secondly, perhaps we simply have to be more creative in application of existing rules. We have to look more carefully at circumstances precluding wrongfulness, valuation, perhaps even enforcement and execution. The ConocoPhillips stay on enforcement decision has a perhaps slightly cryptic note to that effect in paragraph 54. So perhaps we simply have to be more thoughtful in application of the rules that we have. Thirdly, perhaps that is something that is properly the purview of treaty drafters. That is something that they have to address at the level of primary rules in crafting obligations, possibly including caps on liability, perhaps providing for special responsibility rules, perhaps providing for special dispute settlement rules like in the UN Compensation Commission. And there have been some nods in the UNCITRAL working group to that effect in the context of appeal. So perhaps that is really something that states should think about. And finally, to use, I suppose, the yes minister terminology, the most courageous possible response would be to think about an introduction of a principle of exception for full reparation and compensation for cases where compensation is crippling. That could arguably be developed by invocation in individual cases, invocation in multilateral settings. Not at all an unproblematic proposition, and I think I'm trying to be very honest in the paper about possible costs of various kinds of introducing it, but also not something utterly inconceivable. The somewhat analogous principle that I have in mind is contribution to injury. Another principle that has come seemingly out of nowhere, also a vague, responsible actor, favorable principle that has been very much shaped by investor-state arbitration. So in short, either there is no problem, or it can be creatively resolved by existing rules, or it calls for new special rules, or it might even call for a new general rule. So that is, in short, my claim. Thank you.
Great. Thanks so much, Martin. You've given us a lot then to work with. So why don't we then broaden this discussion out a little bit and turn to Jonathan, who has been focusing on the issue of damages and compensation, also from the broader perspective or different perspective. So Jonathan, why don't we get some of your thoughts and reactions?
Yeah, thanks so much, Lisa, and thanks to the organizers for this wonderful event. It's a real pleasure to be invited to comment on the paper, not least because I've been a long-time admirer of Martin's scholarship. And this paper is no exception. It's really detailed and careful in the way the arguments put together, and you will have seen that from the way that Martin's just spoke to it. Because my time is really limited, I'm going to get straight to the point, and I'm going to do what academics do, which is respectfully disagree. And so while I agree with Martin's that there are some very serious problems with existing approaches to compensation in investment treaty arbitration, I disagree that a rule that limits crippling compensation is an appropriate or even perhaps a useful solution to those problems. And I have three sort of main concerns with this proposal. So the first one is that it takes both the principle of full compensation and the way that the principle of full compensation is currently being understood and applied in investment treaty arbitration as given. So that's all taken as given and locked in as part of Martin's proposal. So that's my first concern. The second concern is that the counter principle of crippling compensation is cast too narrowly. So it's not just catastrophically large awards that I think we should be worried about. And even if we're focused just on the question of states' capacity to pay, I don't think that's necessarily an issue that is only engaged where compensation would be crippling. And the third concern I have is indeterminacy. So if you think, as I do, that one of the real problems with the current practice in investment treaty arbitration is that tribunals have largely constructed evaluation and compensation jurisprudence without textual guidance, and that sort of very, very large zone of discretion that's been left to tribunals is part of the problem, then I don't see that very, very general rules, even if they're exceptions, that then hand back a lot of discretion to the tribunals in interpretation and application are really the best solution. So those are, I guess, my three main concerns with Martin's proposal. And in the very short couple of minutes I've got left, I just want to elaborate a little bit more on the first one of those three concerns. So Martin's is really clear and upfront that he thinks that the principle of compensation is too deeply embedded, too widely accepted in international law to be called into question. And I think it's true that there are a lot of international tribunals, a lot of states pay lip service to this familiar language from José Factory. But if we actually look at state practice, and if we look at the design of international adjudicative regimes, and adjudicative regimes are the ones that matter the most because they're the ones where there's actually a chance that whatever remedy a tribunal is empowered to give might actually be ordered. So if we look at state practice and the design of international regimes for adjudication, we can see that the principle of full compensation in the way that it is currently being understood and interpreted in investment treaty tribunals is completely exceptional. So it's not the norm in international law. So if we look at war reparations practice, which Martins discusses, it's very difficult to square that practice at all with the principle of full compensation. It's very difficult to square state practice on the settlement of expropriation disputes by lump sum agreements with the principle of full compensation. The ICJ itself very rarely awards compensation. I think there's only 3 examples where it's done that. That's largely through use of judicial avoidance strategies as sort of practical techniques to get around awarding compensation. When the amounts of compensation, when compensation is awarded, it's generally very small. As is well known, the WTO dispute settlement system isn't empowered normally to award compensation. The European Court of Human Rights does award compensation, but the approach is vastly more conservative than investment treaty arbitration, as you would see by comparing the 2 decisions in the UCOS case, which was litigated through both tracks. So the picture that emerges here is not really one of international law where we have a settled principle of full compensation that is too well established to be tinkered with, but rather one where the sort of lip service that is paid to the principle of full compensation and the way that it's understood in investment treaty arbitration really sits quite uneasily with how international law is actually operating in practice. And so I think this is a really, I guess, a fundamental point of disagreement I have with Martins, is that I think that principle should at least be up for discussion and reconsideration. And that's especially if we're taking the view, as Martins does, and we share this view, that that if we're in the business of reform, international law is something that is open to reconstruction through conscious and purposive action by states. So in summary, the diagnosis of the problem that I would have is much less about international law in general and much more located in the investment treaty system specifically. And the problem, I think, is better solved by reconsidering, or at least opening up to question, the fundamental principles. Thanks.
Great. Thanks so much, Jonathan, and for playing the academic role and doing the pushback. And I think that this exchange is probably worth hundreds of hours of reading. So look forward to Martin's responses on this. And I like also the statement of the, if we are in the business of the reform, both what is the problem and what is the solution? So maybe we can come back to that in the discussion. So let's turn to you, Rodrigo, for some of your thoughts and kind of with the government, a theme working with the government, something that comes up in Martin's paper is the role of the state in creating law, shaping law, reshaping law. So what are your thoughts on either anything that's been said or that particular question about the actual and potential role of the state here? Thanks.
Thanks, Lise. Well, let me thank first Martins for his very interesting article. I think we have valuable insights that are bringing into the debate of this. Some issues were compelling in terms enlightening and compelling from a state perspective, because I think when Martin was throughout the paper, you can see that is a very interesting way in which he frames the role of government or characterize the role of government. And I think, if I am not mistaken, I think he mentioned the issue of he framed the role of government as lack of state practice rather than having state practice. I like that very much. And also the failure of states to challenge the ILC position regarding crippling compensation. So I think when you face this type of situations in which you face a international law principle regarding compensation and full reparation, you need to wonder a little bit what's the role of the state here. And from the perspective of an investment negotiator, it's always difficult to tackle all the issues because as you will see in this debate already, we have different views and different options. So normally you need to translate those into treaty practice actually, to see how to solve issues, and especially when it comes to investor-state dispute settlement and investment treaty. I think there is different ways to tackle. However, what is relevant here is whether you can identify that there is a trend, such as a crippling compensation, in which governments, they might step in and do something. And I think what's relevant is what's the role for governments in these situations. You need to review what has been your past practice in terms of expropriation and compensation, the way that you regulate those in investment treaties, to see whether it would be a possibility under the agreements that you have negotiated to have such an outcome that I think is not desirable from a public perspective. I think I can understand the underlying discussion about international law here, but it's also relevant all the scrutiny that we have been facing in the recent years about ISDS system in general. So this type of awards, this type of situations are not helpful for governments in terms of continue doing the same thing. So the question is, what do you do in your state practice? And one of the issues that I think is relevant is that throughout state practice and opinion juries, we are creating and we can frame again international law. And I think that's relevant for governments. If you review the cases that was mentioned in the article, I think you can imagine that those respond also to older treaty practice in terms of Venezuela, Ecuador, not sure about Pakistan, but I think responds to old treaty practice. And I think one of the other issues that Martin's mentioned in his paper is about this try to multilateralize the approach to conceptualize a little bit state responsibility in multilateral terms. And I think that's the role for governments here. It's like Chile has not been awarded this type of crippling compensation that it has been framed in the paper. However, it is relevant for the government of Chile to do something about it. And I think this is a little bit about multilateralization and also a bit about what's the government role here. We need to address issues, we need to discuss issues, and to see whether we can change some of our treaty practice. And I think the most challenging issue, and apologies for mixing different topics, is the fact that many countries currently, they do not know what to do, or they don't have a clear path in terms of addressing those risks that you have in older treaty practice, in older BITs that were signed during the 19th and early 2000s, in which, of course, different provisions are a little bit unclear. It's not only about expropriation and compensation, it's about other issues as well. So I think that's also what is underlying under this debate about crippling compensation. Is about the role of states and how sometimes the lack of state practice, or a little bit being more inactive from the state perspective, could create situations in which you start to have a consistent practice that has been recognized by different jurisprudence, and then there is an inaction from the state, and the state may have, not only may, should have a different role and more active role when you face this type of situation. So I think, of course, the techniques and the solutions could be very different depending on countries, but to address the principle and to address this idea, I think that is something valuable, and that's that's the most important that I take from this article and from this study that gives us some interesting arguments in order to continue the debate for this.
Great, thanks so much, Rodrigo. And well, I'll turn to Martins to respond to some of the points, and we'll take in some questions and comments. I'll flag those now, actually, Martins, in case you wanted to respond to those as you're also responding to what has been said already. So we have one question that came in through the chat that was, could joint interpretive statements by state parties be a possible mechanism to limit unjustifiable compensation claims? And I think, Rodrigo, I know that we've worked and talked about that a lot on interpretive statements, and there are serious kind of practical hurdles to getting those done. So maybe you can talk about some of the challenges of kind of interpretive statements, either unilateral or joint, and Martins, you come in on that, and John also is kind of relevant to US practice, maybe some of the hurdles around that or opportunities. And then there was another question from Sonia, which I think that we will get to this in the kind of the second part of the program, which is what counts as crippling. Somalia's total reserves are US 23 million, so even a $20 million award could presumably be crippling. So that goes into kind of the operationalizing point of how, if there were such a rule, how could it actually be implemented? And I think that also goes to Jonathan's point about the indeterminacy. So if you do have a rule, how do you actually put it into practice? And there was one more question that came in that I'll flag now. It was, could the issue be considered from a public policy perspective, as it appears to have occurred in relation to the refusal to enforce the award in Al-Kharafi versus Libya, following a decision of the Cairo Court of Appeal. So this probably, I don't know if this fits in, Martins, to your point one, that this is not a problem because it will be dealt with elsewhere, or if that maybe fits into one of the other kind of 4 areas of response. So Martins, yeah, back to you. Thanks.
Well, thank you, Liz. Wonderful questions. And I mean, Jonathan raised 3 points on whether I take full compensation too seriously, on whether I conceive of the possible exception too narrowly, and whether there's a problem with indeterminacy. And I will take on the first and the third one. I think on the first one, I think that this is probably where we'll have to agree to disagree. And I think that probably could be a little bit of a meta question about how we think about the identification of international law in the area. Because I don't think that I would majorly agree with your basic thrust that full compensation, even though proclaimed in principle, has mostly been modulated in practice by various institutional aspects. And I think that is also something that underpins very much Crawford's third report and the International Law Commission's idea. And I think that Crawford is really even quite adamant in the ILC discussion that, look, this is not really about rules, it's about people not being stupid. We once tried to push full compensation in the Versailles Treaty. That did not work very well, and we just expect that states are sensible. And there are, I suppose, if we look from the perspective of investment arbitration, we might say, well, we sort of can see the turning points in international law, why such points are never really pressed. So this is something where states might simply choose not to press them. This is something, as you say, where there's something that might be at the level of a bigger lump sum settlement. There may be a closed docket for international dispute settlement body that can just resolve everything in one fell swoop, or procedural peculiarities, or if we have long-standing institutions with some sense of political survival, like perhaps in the regional human rights settings, they will be modulated through that. And investment arbitration, as it were, removes all those tempering factors. I think that was really Von Lowe's point, that non-state actors are not repeat players, so they don't have the systemic interest in mind. So it's not a criticism of investors, that is simply a consequence of somebody being a non-state actor. I think that those all points are right, but I think it does not challenge the underlying principle. And I think perhaps in a slightly more formalistic way, if we look at the way how tribunals have endorsed it across the universe of international law, how every 3 years UN Secretary General collects decisions and state practice on articles on state responsibility, and with every year we have more and more numerous awards endorsing it. It would be hard to challenge that at the level of principle, even if maybe unwise, it seems to me to be endorsed. I think the additional point that I think perhaps buttresses my naked formalism is that I think it's something that I would imagine tribunals in investment law would find a fairly persuasive point, because if we think of the first decade of this millennium as the time when tribunals were criticized by review bodies by, looking as it were the first slide of the state responsibility lecture, attribution, breach, primary or circumstance precluding wrongfulness. The last decade, Occidental, Tidewater, Venezuela, BV, TECO, we are already in the world where there is quite close attention to the way how the second part of articles of state responsibility content is dealt with. So I think that there would be I would imagine quite considerable hesitance of saying that, even though everybody and their grandmothers accept full compensation, we'd rather not, simply for fear of being reversed. And so I suppose that the way how I wrote my article is for an argument that while departing from the textual expression would go with a broader grain with the system, something that might fit in within the legal argument and state practice, would just be broadly consistent with the mainstream conception, even if moving one textual step further. I think the question on indeterminacy is a hard one. And again, I think I try to be quite upfront about it in my paper, that there's a great deal of problems. So if we imagine one of the respondent states like Venezuela, that is facing a number of multi-billion claims in unconnected proceedings, possibly represented by different counsel, without what appears to be much of coordination in strategies and expert approaches. So even if one tribunal were to say that is a relevant legal consideration, how would they implement it? I'm not at all saying, as it were, if I started to think about an ideal version of state responsibility, that is how I would put it. But I suppose, again, being rather pragmatic, it does not seem that this is a time for an international institution on these matters, a sovereign bankruptcy court of sort. Perhaps my judgment of the politics is excessively cynical, but I don't think that the attitude has improved in the last 15 years or so. So the argument, so it seems to me that the least ill-fitting place, as it were, where it can be put in the legal argument is this, a narrow exception to full compensation. And as a general proposition, it seems to me that international law is not incredibly uncomfortable with indeterminacy and with the idea that we have a vague principle, we have a way of asking questions, and we have an ability to identify relevant considerations in response. That is how law of the sea works in delimitation. That is how transboundary water works. In the better instances, that is how fair and equitable treatment works. And I think, contribution to injury, I know there is reasonable disagreement about how well it works, but the sort of idea of tribunals building on each other and trying to generalize about relevant circumstances in the sort of the copper mesa and Ecuador type of situation seems to me to be not a very problematic analogy. I think perhaps this is where I can also touch upon the enforcement point, whether that is something that could be put at the enforcement level. And that is one possibility. As I said, if a bit cryptically, it seemed that that is what ConocoPhillips and Venezuela Annulment Committee has in mind. If you have a look at paragraph 54 of their stay of enforcement decision of November, they allude to something of that sort. And arguably that would be consistent with a broader balance of the international law commission struck as well. I suppose it's really sort of more of a question of how easy that fits within the broader teleology of enforcement regime under New York Convention and Exit Convention. And I think, other people present here will be much more knowledgeable, but I don't think that it would be fully consistent with sort of the mainstream reading of both of those regimes, but very happy to be corrected. There is very little that I can disagree with what Rodrigo said. So I do think that this is something where states play an important role. Indeed, I highlight in my paper that Chile was one of the states that did speak out on the topic in the Sixth Committee and argued that there should be an exception for crippling compensation. I suppose perhaps in some ways even my argument is a slightly utopian one, in a sense that these are things where even a relatively small investment by states in formulating explicit practice can be a driving force. So if we look at the International Law Commission's debates, we have on the one hand, we have US, UK, France, Japan, Australia and Israel. On the other hand, we have Germany, Italy, Chile, and Bahrain. So, limited numbers of states, and if even 5 or 10 states, if even all states who have been respondents would have intervened explicitly, that could have arguably changed the outcome, because again, Crawford was quite conscious and was invoking the fact that states were critical of the matter. So taking explicit part on the matter, generating state practice over a long period of time is an important element. And I think on this point, perhaps the fact that we would conceptualize this analytically as a question of state responsibility makes the usual concern about the old treaties slightly lesser, because customary law would be equally applicable to all treaties, be they new or old. And therefore, in a way, to the extent that states manage to either agree in a smaller setting or formulate in a broader setting applicable customary law, it would have immediate general application whenever the treaties were accepted. Now, whether that could be done through joint interpretive statements is a good question. I suppose in a conceptual sense, the idea of agreeing on what a general rule means in a bilateral setting is interesting. I suppose the analogy could be the North American treaty practice, where United States and Canadian treaties routinely include explanation of how we approach customary international law. Again, also a general proposition about foundational issues, but routinely included in bilateral treaties. And the Dutch modal bilateral treaty has a nod to both lawful and unlawful expropriation and remedial consequences. So it is possible to imagine how that would be done. And I think that there are lots of creative ways of thinking of how to generate customary international law, whether by having a general statement to which willing states accede, or indeed having it in such setting. But I think it's really sort of worth noting that the fact that we analytically conceptualize this as relating to all breaches of all treaties rather than specifically relating to one treaty is an advantage for rapid change rather than a disadvantage. And if I could just make the last point, I think that on this is also a topic on which states can afford to be a little bit opportunistic, because there are a number of points on which tribunals have gone against at least the grain of ILC's thinking. So as many of you will appreciate, ILC was a skeptic of compound interest and at best a lukewarm attitude holder to discount cash flow. And on both of those things, the grain of practice has gone against them. So there is no reason for absolutizing the position set out. It is a starting point which can be modified by general differences in practice. I think that is probably what I wanted to say right now. Thank you.
Thanks so much. And I think I imagine, Jonathan, you'll want to respond, and also Rodrigo, I had also signposted to you and asked John to come in on the interpretation point. But why don't we maybe shift to those from whom we haven't heard yet and discuss some more, and then we'll come back to everybody again. So Viren, how about we turn to you next. You also represent claimants, so maybe you can give us a perspective from the different side of the table.
Sure. Thank you for having me here, and congratulations to Martins for your paper, which I found to be very thought-provoking. There is to some extent in the paper a discussion of how this rule could be introduced, and some of that discussion is directed towards state actors, for example, because they are involved in treaty negotiation, and options to them such as joint interpretive statements. And there is this sense in the paper and in commentary today that the investors as non-state actors in this process of establishing the foundational instruments may be opportunistic or don't have much role to play in the system of dispute settlement of investment arbitration disputes beyond maximizing the return that they get out of their individual case, and therefore what are their incentives. And what I will say, representing claimants frequently, is the point that Jonathan made about indeterminacy. At the end of the day, lawyers and we have the tools that are available to us to make out the case for our client's position. And there are examples of treaties that do specify in more detail what the standard of compensation or full reparation should be. I saw that there was an example in the chat from the COMISA treaty. I think in your footnotes, Martin, you mentioned that Iran and Slovakia have negotiated a BIT in 2016 that includes a factor that the interest of the private actor or the claimant should be assessed against the public interest, and some sort of weighing assessment or mitigation assessment likely would go on in that circumstance. And so therefore, one of the biggest criticisms that I have of the crippling compensation principle is this indeterminacy point of how would it be applied in principle, and what would be the investor's position here, where it may have obligations to its shareholder to go out and maximize the damages for what it has incurred without a view to the larger issue. Now, many of the examples that sort of are in the media and get a lot of attention and frankly are discussed in the paper are those that are awards that exceed $1 billion. They are really the minority of awards that are rendered, right? So we don't want to lose the forest for the trees, and that these are very big eye-popping awards, but they're also not the norm in terms of size of damages typically awarded. But what's interesting to me also, though, is that a number of those awards are in the natural resources sector. They involve oil and gas projects, or they involve mining projects. And here's where this indeterminacy point comes in, which is, when you look at Article 36(2) of the ILC articles, they say that compensation shall cover any financially accessible damage. So you do have to prove the financial damage incurred by the state's misconduct that breached the treaty, and you may be able to get lost profits if you are able to establish what those lost profits would be. And so what I find interesting is, there is a burden put on the investor in this case to prove that it is entitled to lost profits. And what parties have essentially done, and tribunals largely have blessed, is in the absence of any other guiding principle in the treaty or under customary international law, then when, for example, looking at the oil and gas sector or looking at the mining sector, they've gone to what has been promulgated in those industries. So for example, the JORC standards in Australia or the SIMVAL standards in Canada. And those standards look at, what form of compensation, or rather what would fair market value be for projects that are in prospection stage, or that are in exploration stage, or that are actually in development and production stage. And if it is very early up front and you don't have things like pre-feasibility studies, or you don't have definitive feasibility studies, or you don't have competent persons reports identifying with some degree of certainty what are the resources and reserves in the ground, for example, that will be produced from the mine, then chances are it's very unlikely that you're going to get lost profits, because tribunals don't want to award lost profits if there isn't a history of profitability, it wasn't a going concern to begin with, or that there is some certainty that we know the amount of what's under the ground, and we know that it could be taken out and then produced over the life of the concession. So there are some factors that are built in here to assess whether or not those big damages are warranted or not. I mean, in all these cases, in full disclosure, I was involved in the Crystal X case and the ConocoPhillips case. My law firm, King & Spalding, was involved in the UFG case. So I'm not talking really about any of the behind the scenes part on those cases, but if you read the awards, there is a concern by the tribunal that in the Tetian copper case, that the claimant actually spent over $200 million to explore this project and to identify the resources and reserves under the ground, which we can now forecast with certainty using the DCF model, which would be appropriate and is how the industry uses fair market value when you apply the JORC or SIMVAL standards. Likewise in Crystalex, when the denial about the environmental permit was at issue and therefore the project could not go into operation, so it was technically pre-operational, the tribunal did in the merit stage look at was what was being done here just because gold was on the upswing and essentially Venezuela wanted to renegotiate whatever the royalty or tax framework would be, or give it to another investor to develop and not this Canadian mining company that had gone in to do the work. And then they look at sort of the degree to which the reserves and resources have been estimated. They look at market comparables, all of which is to say that there is a lot of thought that goes into the creation of those damages awards, and there is a limitation built into Article 36.2 of the ILC articles, which tribunals take very seriously, of how to calculate those damages in the natural resources sector. So the issue then with the crippling standard is how would it apply, right? What would it be? Is it essentially you apply a damages model if you do sunk costs, which by the way is awarded in a number of natural resources cases, for example, South American silver versus Bolivia, for example, in Bear Creek versus Peru. Do you come up with a number and then apply a haircut, to the Somalia point, that because the 23 million in trade reserves, what does that mean for what should be the discount applied on for that country specifically in the damages award? It's quite hard to do. I think for an investor at least to plead out, and frankly for the tribunal to do in a way that may not seem arbitrary. I know my time is up, so the one last comment I'll make on this enforcement point is, there is nothing that prevents states from settling disputes up front, right, during the negotiation or cooling off period. And frankly, after an award is rendered, it can often be a slog for an investor to get that award paid out. You have to go through annulment proceedings, potentially. If it's in an unsubstantial case, you may have multiple appellate review before the annulment proceedings are completed before the set-aside court. States still may not pay up, and then you've got to go to the enforcement courts. And there was a suggestion that maybe public policy could be used, to not enforce the award. I don't endorse that proposal, because I don't see why that necessarily has to be the guiding factor. Typically, at the enforcement stage, there's a question of, especially with the ICSID convention, you have to essentially treat the judgment as though it were rendered by a sister court of that state, and the exceptions are very narrow. While there may be a public policy exception, I think it would be quite broad to read it that way. But frankly, investors would take a significant haircut if asked by the state, measuring their circumstances. Venezuela is in a state of crisis, or we reasonably cannot pay out this award except over a period of time, or with some degree of coming back in to develop the project, or through bond offerings that'll issue over a couple of years, frankly. And so there could be that haircut because of the reality of a crippling state of affairs in a country that comes in at the back end. And so maybe some of that is left to how it plays out, but is not for a tribunal to do. All right, thank you, Lisa.
Thanks, Björn. And just to also flag that we also had another question come in from Joshua Payne on DCF, which I think goes to some of the points that you were making. So maybe we can return to that when we open it up again. Christina, I'm just going to turn right over to you for your thoughts on anything that's been said or on the paper. Thanks.
Sure, thanks, Lise. I'd like to start off also by congratulating Martins on his really timely and innovative scholarship. It truly presents a number of really important findings. For me, the discussion about the ILC's reversal of its position in 1996 to its eventual adoption in its current form in 2001 was really eye-opening. As was the suggestion in your article, that perhaps we might not be having this discussion had several key figures remained at the commission at the time of the second reading. So that was thought-provoking. As counsel for states, I am particularly sensitive to the potential impacts of crippling damages awards, and we've discussed a number of high-profile examples, not just the ConocoPhillips matter, but even the $6.6 billion award in the PNID versus Nigeria case. This amount is said to be about 8 times the country's national health budget, which is truly shocking. And These aren't isolated anomalies, but I think they rather reflect sort of a broader trend in investment claims. I took a look at the UNCTAD investment dispute settlement tool last night before preparing for today, and it shows that approximately 27% of investment claims, that is just the claim itself that has been brought by the investor, have been upwards of $500 million. And if we look at investment claims over $1 billion, this accounts for about 15% of cases. But I take Viren's point, these actual awards that result in these the scale of damages is a much smaller proportion of these actual claims that have been brought. But I think the threat of a large damages award really looms large for states as long as claims of this magnitude are being brought. And I think it's also important to understand why these claims are so large. In my view, one of the main reasons is because counsel and quantum experts alike have internalized a certain reduction in the amount of the damages awarded in most cases. PwC produced a study in 2005 that found that the average award is approximately 37% of the amounts claimed. But it's clear that in some cases, tribunals really do go along with some of these outsized claims. And I think that's why Martin's article is really important, because it really takes us back to the origins of the investor-state dispute settlement system. BITs are known to have been viewed as tools for economic development by states. So I think ignoring the impact of a crushing award on the economic development of a state really cuts against the very reason that the system was created in the first place. And this brings me to a key question that the article poses, which is why don't we challenge crippling compensation claims in investor-state arbitration? And to be honest, from a practical perspective, I think we would first need to resolve a few key issues, which several of the speakers have referred to as the problem of indeterminacy. For example, would this exempt the state from all financial consequences? When is the relevant time to consider the conditions of the state? By what metric would an award be deemed to be crippling? And most importantly, I think, would there be a sufficient legal basis for a tribunal to be comfortable to grant this sort of relief? And as a result, I do think there's a lot of force in Martin's own explanation that he presents in his paper, which is that of path dependency. But to this, I'd also add, there's also a certain degree of lawyerly conservatism. I think we should acknowledge, however, that there are certain ways that counsel have managed to bring these issues before tribunals with varying levels of success. The defense of necessity has, of course, been very problematic. It's encountered mixed success, but it's there in customary international law and in many treaties. Also, equity could be relevant as a general principle of law, and for equity, ex equa et bono. Clearly, none of these are perfect substitutes for Martin's crippling compensation exception. So I think there is real merit in the position that Martin's has advanced so ably. But personally, from the perspective of state counsel, I think this is really an issue to be taken up by states, whether in their bilateral investment treaties or at the multilateral level, for example, through the UN General Assembly Sixth Committee, the OECD, or the ILC. However, I don't think that the current reform processes underway at ICSID or UNCITRAL would be a really viable route, largely because they're focused on procedural reforms. So I understand we have limited time, so I'll conclude my remarks here. Thank you.
Thanks, Christina. That's actually a perfect segue because we have John Daly. Well, I know that you're making remarks in your personal capacity, but work with the state that has both a respondent and a home state perspective. So yeah, thoughts on anything. Go ahead, over to you.
First of all, thank you for inviting me to participate in this. Thanks for everyone for watching, and thanks especially to Martins for his paper. I also found it very interesting, and we owe him some gratitude for it because it does open up a lot of avenues for considering this. So I'll touch upon a couple things. One, I think is just I would offer a word of caution, or at least consideration on talking about identifying state practice. Don't forget the opinio juris prong of that. Because it's very complicated, and you're sort of taking settlements, for example, or the post-war settlements. You know, at least in my experience in being engaged in settlements, it's not very frequently when you conclude a settlement that you think that the amount of the award or the settlement or all the terms of it were required by international law. You weren't acting out, you know. And I think the most important thing is to look at the claim, and that can be very challenging for researchers to do. But I would just sort of offer that. I think the ILC recognized that as well. As to the question about joint interpretive statements, I think that is an interesting one. I think it may depend upon your treaty. If you're interpreting a treaty, then it depends upon the terms of that treaty and how broad they are, the extent to which they incorporate general principles of international law or customary international law. So that may not be a solution for everyone. The other point I would just make in doing this, if countries are considering going down the do it through litigation route, I'm not sure it's just enough to have respondents weigh in. It's not clear to me that a respondent is really acting out of a sense of legal obligation when it's saying I shouldn't have to pay this. It's really the claimant that's more relevant that would be constrained. So if you have a state-to-state proceeding, that's one thing. But there's at least a question in my mind when you have an investor state proceeding, is that how you can't really make the claimant say that. The claimant state, I think, is relevant. And then you're at the mercy of whether you even have an ability to weigh in. Some treaties do allow non-disputing party submissions or friend of the court submissions. And if you can raise these issues during those, depending upon the breadth of your treaty text, you may do that. But I think in practical terms, that may not be so easy to do because in the context of a spousal or diplomatic protection, you've already made the political decision to bring the claim on behalf of your national, presumably because it's a very, very sympathetic claim or important claim, or because your national is politically connected. And the chances of then turning around and telling that national, not only aren't we going to get you all your money back, but we're not even going to ask for it, could be politically challenging. So we think I have to go into this with open eyes. Things to consider, but I think states, if they're going to do this, really need to think about it in broader terms. So I tend to agree with Christina that it may be the treaty route may be more fruitful to look at. The other thing I would like to do is think about this a little bit from the perspective of if you were going to try to do it through litigation, if you will, and leave kind of the broad contours of this to judges and arbitrators, going to the indeterminacy point, how will that change the way those proceedings look? And I'll start with one point, which I think is often overlooked, which is just constructing your tribunal or your court. I think it's getting better, but I think in general, I've found that people don't think of the damages issues when they're choosing their arbitrator or designing their perfect court, because no one wants to think about the scenario when they lose. And I think that's a mistake. I think it's getting better, but I would say that if this crippling compensation rule is going to be, whether put in by treaty or put in by practice, that adds a whole other layer of complexity to what your arbitrator's profile would need to be. Now you're moving into the realm of macroeconomics. So it's one thing to do a DCF properly. You're taking it one more step. And what does that do to your pool of arbitrators? And I think the same is true for a standing court, and it may be even more complicated for a standing court. So that's one thing to consider. Another point, if you look at in the proceedings, and this goes back to the indeterminacy point, let's assume for the moment that a small claim that is hitting a state that's in distress is sufficient to engage the crippling compensation rule, the straw that breaks the camel's back. Maybe $1 billion straw is not a fair way to characterize it, but I think, as Jonathan pointed out and others, it could be smaller amounts. Well, look at that in practice, at least from the perspective of a state and counsel of a state. let's say we have a state that's not quite in distress, but it's just very, very close, and a couple of words, a couple of cases come in, and you're now going to convince your client to let you raise this defense. Well, what's going to happen, or what could happen? So the technocrats, the people in the finance ministry that are trying to renegotiate debt already, I think they're going to be a little bit nervous about you pleading poverty and showing how bad things are at the very moment when they're trying to turn it around and convince major creditors that the state can pull it together. So you may have some resistance there. And I think you may have some resistance from politicians who are not going to want to lay bare to the world how bad they allowed things to happen. So I think if a state is already in distress, it may be a lot easier. But if you're kind of on the brink, I think you will face those pressures. And so I think it's very important, if you're going to go down this path, to have a kind of deep and broad commitment to the principle first, and recognize what it could mean. Another point I was thinking of was discovery. And if you are in proceedings that are going to allow for discovery, what is discovery going to look like on this question? You're going to be kind of assessing the validity of statements about a balance sheet of a state. What are the liabilities, but what are the assets, and maybe where are the assets? And in that latter respect, there's a risk that you create a roadmap or maybe a treasure map for claimants counsel. And if the defense doesn't work, or even if it does work and you have a smaller award, have you just made it easier to go find assets? And that may not be so manageable with confidentiality orders or things, because, unlike a situation where you have trade secrets, where you're trying to keep someone from external to the process from getting the information, here, the very information you're talking about, it's the other party that you may want to keep it from. And even a attorney's eyes only kind of confidentiality order may not be that useful, because that attorney is most likely going to be involved in enforcement proceedings later, or at least could be. So it may just have to be a risk that you accept if you're going to raise this defense. Now, that may be both of those factors may temper abuse. And I should say the United States at least expressed views at the time this was being debated in the ILC, was worries about abuse, that it was going to be raised all the time. And maybe the factors I just talked about will temper it a little bit. But I do think those are risks that you need to think of. And so, my, I think, takeaway point is, I agree completely with Rodrigo that states would need to take charge of this. And I think if you're going to go down this road, you would want states that are claimants to be weighing in as well, because I don't think that it works if just the respondents do it. And that requires coordination, and that requires some guts and some commitment to the principle. And then I think also you have to be willing to take some risks when you're raising it, and the sort of things that I talked about. And so I think there probably are more questions and more problems that we would want to address. And I would encourage, states who get serious about this to really think about the practical aspects, because if you go down a path of something that's not going to be usable for you, you're putting in a lot of effort. So I'll leave it there, but those are my kind of practical comments, if you will, just looking at this from a practical perspective, is how it would work out. Thanks.
Great, thanks so much. And there's been there's a lot now for us to work with. There was a comment from Howard Mann in the Q&A talking about maybe kind of the systemic reasons why the issue of crippling compensation is with us. And that's a kind of a butchering paraphrasing of his comment. So maybe we can also look at that. But it reminded me of Martin's, what you found in your paper too, about the fact that there has been departure from the ILC rules in the context of compound interest and discounted cash flow. And there have been some other discussions of discounted cash flow. Is that kind of related to Howard Mann's point about the kind of systemic design, the context in which we're operating, or is there something else behind that? I don't know if anyone wants to pick that up, but why don't we go back to the beginning where we started with Jonathan, and if you want to pick up on anything that has been said, including going back to kind of the initial exchanges between you and Martins on the rule itself. Thanks.
Sure, thanks, so much. I won't go back to those exchanges straight away, but I will come in, and I think just to echo the point that Howie and Josh were flagging about DCF, and I think Martin's probably would agree with this, or I won't put words in his mouth, but investment treaty tribunals have taken, I think, a kind of quite selective attitude to the ILC articles in relation to compensation in particular. So both on the question of DCF and more specific questions relating to how concepts of causation and remoteness are conceived within the confines of the technical structure of a DCF model, interest as well. So these were all questions which the ILC took a relatively conservative approach to, and what we see in the ILC's own statement, and I think Martins and I are really on the same page with this, is a very strong sort of in principle commitment to the principle of full compensation up front, but then a very restrained articulation of how that principle ought to be operationalized, and a set of deeply embedded assumptions about the political and institutional constraints that would prevent overreach. So I also agree with Martin's diagnosis, I think to some extent, that what we've seen in investment treaty arbitration is a kind of decoupling of this headline principle of full reparation from all the institutional constraints, from all the political forms of accountability and reciprocity, from a lot of the caution that was built into those doctrines. So there has been a quite selective sort of re-articulation of those principles within the investment treaty system. But whether, it's enough at this point just to say, well, the problem is just DCF. I mean, I'm not sure I would go that far, because, the nature, and I would be interested to hear sort of Viren and Christina's views on this, but the nature of DCF, in my opinion, is also that it's an extraordinarily malleable technique. So it doesn't necessarily come up with extraordinarily large valuations, but it's very easy to make it do that depending on what you plug in.
Thanks, Jonathan. Martins, why don't we go back to you to respond to also anything that had been said by the final three speakers and anything Jonathan said, and also there's a question to you from Simone Badifort in the Q&A.
Thank you, Liz, and thank you for the enormously rich comments. I think I'll probably just make a few brief points, probably really one in relation to each of those. I mean, I think in relation to Viren, it's fair to say that I think that Viren's perspective is probably reflective of what mainstream international law looks at it. And I think that is what Oppenheim says, as if I may be indirectly boastful as the contributor to the 10th Oppenheim on the same topic, I'm naturally partial to the Oppenheim's authority. And Oppenheim says, look, there are all these ways of tweaking, but ultimately it's a negotiating point. Reasonable people will come to an agreement. I mean, I think that you're absolutely right that there are various ways how we can articulate arguments against a claimant. Basic questions about loss and causality. So I think that in Pay Casado too, Sir Frank made a number of important observations on that point. Contribution has come in. I think mitigation is increasingly coming in. So I think in a way I take it all as a given. So I'm not at all disagreeing with that. And I think in terms of intellectual practicalities, it is also an interesting point, and we can think of articulating in at least two different ways. And I think that even in the first reading, ILC was sort of suggesting two things. Either it is one element that could be taken into account among others when you are coming to the number, as it were, evaluation internal point, or it is an external cap. And that is the way how the Eritrea-Ethiopia Claims Commission, and with extremely solid people, well familiar to all of you, Lucy Reed, John Krug, Hansen Hood. So people who have a good sense of how these things work in investment arbitration as well. So I think it's really, and I'm trying to be very honest about in the paper that even if one were to go in that direction, there's an incredible number of further choices to be made. I think I'm really very much in agreement with points that Christina made. I don't think that I really have even any major, as it were, pushback on that at all. I think it did strike me the sort of, I suppose, really the accidental nature of international lawmaking, and also perhaps a broader background question in interventions by states, to what extent silences are reflective of choices to be silent or reflective of the allocation of resources to international legal advice that particular states can make. Obviously, kind of the broader political, international political economy of international law. And not everything can be solved through this, but I think that is certainly in the background. I mean, I don't think that, again, I disagree with anything that John said. I think settlements are certainly extraordinarily hard to pin down an opinio juris point. And I think that was indeed the interesting thing in the International Law Commission was that, Germany and Japan, both of which probably know something about settlements of war reparation claims, took the absolutely opposite positions and conclusions on these matters, and so did Italy. So these are hard questions. I suppose in intellectual law, sources sense, I would completely agree that the non-disputing party states' use would be important. I wouldn't be so quick, perhaps, to completely dismiss the respondent states' views, because I think that I would say that there are the two elements. At first, that non-state actors are important and, as it were, acting as catalysts for practice. I think that is consistent with the ILC's conclusion on custom, I think conclusion 4.3. And secondly, arguments in denial of principle also seem to me consistent with opinio juris in light of the jurisdictional immunities case of the ICJ. Now, obviously, it goes to the weight point. There are all the arguments about it being incredibly opportunistic, but again, sort of saying that even if opportunistic arguments are not made, it must be a judgment that the argument is very, very low indeed. And the points about various arguments that I suppose really constrain putting forward the legal argument in formal terms are right. And I think it's perhaps a reminder of which I'm also very conscious that we may think in international sometimes of stated black boxes, but formulation of a legal proposition, of course, is also an internal political process. I can think of one case involving United States, where United States decided not to take any view at all on a legal proposition, which some people thought reflected lack of internal agreement. And absolutely, I think that there are many things that silence may signify lack of resources or lack of internal agreement, but international lawmaking is, in a sense, a rather cruel and unforgiving science. It does not care majorly why states have not articulated practice of opinio juris. If they haven't, as it were, they will be held to the absence of their word. Simon raised a great question about whether we need to sort of think about it differently, and pointing to Zach Douglas's argument that ILC's articles will not fully be applicable. I mean, to be perfectly honest, I'm not entirely persuaded by Zach's point, because he intellectually locates himself, at least in his British Yearbook article, a little bit less after that, in sort of the intellectual tradition of Riphagen, who is perhaps the forgotten ILC rapporteur, because he thought that there should be different roles and responsibility for injury to aliens, and everybody thought that that was a silly idea. So it's perhaps not the strongest possible pedigree on which to bring an argument for a different approach in contemporary law. Having said that, I think that there is some decent authority, including, I think, at least one annulment committee on which Crawford sat, MTD annulment, that we can reason about these matters by analogy. But it seems to me that, I suppose, I mean, I wrote an European Journal of International Law paper about a decade ago, so phrasing it as a question and suggesting that if arguments are not raised, it's most likely to be endorsed, as it were, by the fact that states are not challenging it. And again, I think that, if states had raised these questions in annulment committees from the get-go, say from 20 years ago, about the manner in how Part 2 really fits in investment arbitration, we may be in a different world. But again, sort of I suppose really the shaping of professional consensus that some arguments are just too outlandish to be raised in a formalized setting. I mean, it may not be quite opinio juris, but it's sort of, reflection of what the professional bar of investment law counts as a plausible argument is very much that what has shaped international law in the area. And I think that to some extent, perhaps with some squeakiness, we can put that within the normal means of lawmaking box.
Thanks, Martins. Thanks for those great responses. Rodrigo, there was, we turned to this issue of the role of the state in negotiations as well. I mean, I know that's something that you've participated in UNCITRAL in the context of OECD. I don't know what your thoughts are about the possibilities, the challenges of kind of more actively shaping the law in this context, or any other thoughts?
Thank you, Lisa. Well, I think it is clear that there is a role for governments. If you look at the cases, the ISDS cases that have been mentioned in the article by Martins, you will refer that the underlying BIT behind those disputes are one of 1991 between Netherlands and Venezuela, and the other is 1998 between, for example, Pakistan and Australia, I think. I was doing some digging before this webinar, and just a quick review of those agreements. You can say that the standards contained in those are not enough, are outdated, especially what has been the meaning of recent treaty practice in different agreements. If you take into account, for example, even CPTPP or recent agreements made by even the European Union with some trading partners, it's like you're trying to address many issues that could be underlying concepts and principles, or even treaty provisions that might affect or create some sort of pathway to get into those type of compensations. Because compensation is not only about valuation of damages, it's also about what has been the breach, that you've basically, what's the state responsibility, what are the different obligations that the state has been breached throughout the application of some measure. So if you try to limit those also, like the liability of states in terms of a well or better drafted minimum standard of treatment provision, that you deal with issues such as expectations, where those expectations are included under the obligation or not, or under what conditions expectations should be treated. Then if you have clear rules regarding expropriation and compensation, I think Martins made a good point in his paper about how you drafted, whether it's like you cannot do X, so far if you do X, you need to pay compensation, or the other way around is that you can do S unless you pay to the extent that you pay compensation. So it's terms of also the legality of the actions taken by the state that could amount to much more responsibility in terms of valuation of damages as well. So I think this is something that we need to bear in mind, that is not only about the compensation, it's about also what has been the illegal acts conducted by the state, and in this way, I think treaty practice should play a role. And then my last comment here is related to my initial one. We're referring to older BITs, and often you see, and I don't have the statistics here, that basically you will find responsibility of states and liability in awards when it comes to this type of treaties, older treaties. And normally what has been like a trend, at least that I have been following the region with with my neighboring countries is that when you are talking about, and when it comes to a claim based under a recent investment agreement or investment chapter in the context of free trade agreements, there is more difficult for the claimant to prove actually wrongdoing from the state, like to basically, so in that context, I think there is a role for governments. There is an opportunity here right now on UNCITRAL discussions. I know that it's all about multilateral investment court, but there is some issues regarding damages as well, that it might be an appropriate forum to have a discussion. And I think that's a very interesting role for states to do that. But it's also, there is a role for states to do something about older treaty practice that is still in force, and we're still dealing with the consequences now.
Thanks, Rodrigo. I'd be interested in you had flagged, Martins, also UNCITRAL as a potential avenue, and I'd be interested in thoughts on the role of UNCITRAL to address the issues of damages and compensation. It's something that we flagged, but often hear pushback either because it's not within the mandate. That's, I guess, the main one. So if anyone wants to pick up that topic, it would be great to hear some more on actual viability, feasibility, desirability of doing it there. And if not there, then where? But Viren, why don't we go back to you, see if you have anything to respond. And there's also a question in the Q&A from a quantum expert in ISDS case. I don't know if you saw that one and want to add any thoughts on that.
Sure. I mean, to the question about the standard of proof and proving out the parts of your DCF model that make whatever damages are being awarded not speculative, but grounded in some degree of certainty. You know, the comment suggests maybe it's 50%, 51%, and maybe that should be a higher burden. I do think that tribunals are relatively sophisticated when it comes to looking at the inputs that go into the DCF model, and frequently there is a battle of the experts from the quantums, you know, from the claimant side and from the respondent side, and it can be multiple experts that go to whether financing would have been available for the project depending on what was going on in the industry or the country at the time, or what were the reserves under the ground, or what should the discount rate be. So I mean, they made the ILC rules do say that, you know, you have to prove this up. There has to be some basis, but maybe there's some room for what that burden of proof should be. And to Jonathan's point, you're right that fine-tuning the DCF model results in drastically different outcomes. And one of the things that you frequently see in discussion is whether the discount rate should be higher if it's a riskier project, or lower. And that has even tweaks by 1% or so can have hundreds of millions of dollars of impact in what your damages will be. Sometimes tribunals, you know, have to take into account whether there is a country risk premium to be added based on what was going on in the country at the time of the investment. And while this may not necessarily be tied to whether the damages award will cripple a country, because it may just be, you know, economically struggling, some of the underlying conditions, whether there's been violence or political tension, gets factored into that country risk premium, which could be added to your discount rate to then drive down your DCF outcome. The only other point I wanted to make, you know, in the paper, and I think also Martins, in your comment today, you talked about the sort of timing of when the ConocoPhillips award came out in 2019, and then Venezuela's comments about the state of its economy. And you know, there's a drastic, there's about 11 or 12 years between the data valuation of when the breach occurred in that case, 2007, I think, and 2019, when the tribunal awarded the damages. And you know, if you're putting yourself into the data valuation, you're looking forward then as to what a willing buyer or seller would agree to based on the information available to them. And it's sort of an ex-ante approach, as opposed to in 2019, when the tribunal's rendering its decision, looking back at what actually happened to, you know, oil prices over this intervening decade and so forth. The look back is hard to factor in analytically to say that at the time I'm rendering my award, I must also take into account the circumstances in a country and the state of their economy versus what was happening when the breach occurred, which may have considerable lag. And that's something that also will complicate a little bit this haircut or discount that might come off applying the crippling approach.
Sorry, I couldn't find my mute button. Thanks, Vera. And Christina, why don't we go to you for any thoughts in reaction to what's been said, and also any concluding remarks. And John, I'll do the same for you. And then Martin's, just a heads up, I'll give you the last word. Okay, so Christina.
Thanks again. So I'll pick up a bit on the point about the DCF as well. I think whenever discussion is raised on full reparation, what it means, we automatically devolve to discussions about the DCF, which is not necessarily an automatic connection that needs to be made. There's many different methodologies in which you can use to implement the full market value standard that is often associated with full reparation, at least in the context of expropriation, expropriatory breaches. The problem is not necessarily with the methodology itself as much as with the application. The DCF method is merely a tool. When you start seeing these outlandish valuations is largely a result of the inputs that are used. And I think that's why you see tribunals, at least as a traditional position, being very skeptical or reluctant to use the DCF without there being a history of operations or a track record. Buren in his comments mentioned some tribunals that have been willing to depart from this approach in the context of the extractive industry due to, reliance on, for example, mining studies like feasibility studies. And I think that it's really important to bear in mind that even with these feasibility studies, there is still a high degree of risk associated with any mining project before you even begin to extract any metals. I work quite frequently with quantum and mining experts, and I'm often told you don't know what's there until you start digging. So to award damages purely on the basis of a feasibility study, which has accuracy level of plus or minus 15%, or even a pre-feasibility study that has an accuracy level of 20 to 25%, I think is it should give everybody pause before really basing evaluation on those documents. The other point I just quickly wanted to raise is really an observation about how the ILC has, in some instances, departed from some of the commentary. And I would note that when that happens, it appears to be usually in a way that's more favorable to claimants, for example, in the circumstance in which the DCF might be applied, or even the application of compound interest. So I just put it out there. I'm not sure if that necessarily will lead to a broadening of positions that are more preferable to the state position, but that's the current state of play. Thank you.
Thanks, Christina. And then to you, John, briefly, and then to Martin. So somehow we're nearly at the end of time. So if you can be quick, that'd be appreciated.
Sure. So first, I agree, Martin's, with your point. And I didn't mean to suggest that respondents' views, have no weight at all. They certainly will in forming customary international law. My point is just that I don't know that it'll be enough. And so I think that other states sitting on the sideline, that's an unfair way to put it, will not be helpful. And so to me, the big takeaway is that if this is something that states are interested in doing, you have to really commit to it, I think, and take the time to overcome, as Martin's put it, the unfairness of international law as to silence. And that's often a resource issue. I mean, I can say from my own experience, the United States, we have a whole team that I work with that just looks at ISDS, and we can't always cover everything. And so I can't imagine what it has to be like for other states if they're doing this without a big team and relying on outside counsel. But if it's important enough, you've got to find a way to do it. And so that's sort of, I think, my main takeaway is that you've got to commit to it and work within your own government to get buy-in, early and often, because when your opportunities come, you're going to want to take them, and there will be obstacles to taking them, I think. So I'll leave it at that.
Thanks, John. Martins?
Thank you, Liz. It's such an extraordinarily rich array of comments. I think if I sort of needed to summarize where I find myself in the end, I think to some extent it does seem that we are sort of thinking about the broad balance that the International Law Commission struck and the extent to which the way how it is conceived in this field is, with all tweaks for procedural peculiarities, broadly faithful to that balance. And I can sort of see how there could be a reasonable disagreement, whether, I suppose, on compound interest and DCF going a little bit in the injured actor way, perhaps aggressive application of contribution and mitigation going a little bit responsible actor way, whether there would be a place for a particular principle for this matter. I think that is, I feel that there was really sort of perhaps a broad sense that that broad balance is something that one should be faithful to. And I think that if one, goes in that direction, then there probably are the two ways of thinking about it in the dispute settlement setting and the institutional setting. And I think in dispute settlement setting, one additional point that is perhaps worth noting is to the extent if states think that this is a point worth making, really important to be, as it were, internally consistent among themselves, even if they are only respondent states, that they are consistent amongst themselves. One might think of perhaps a model form, as it were, of pleading, a model form of submission that can be used in that setting. And I think, customary law being a rather snail-paced process, one would probably be not thinking of something rapid, bringing practice over years, if not decades. An institutional setting, there are places where it could be anchored. 6 committees looking at state responsibility every 3 years. International Law Commission, I think perhaps going back to Simon's point, in 2016, Secretariat identified compensation under international law as one of the possible future topics. And there may be other places as well, universally, as well as in the regional setting. And so I think it really probably falls down finally to the way how we think about the practicalities. And there are probably many ways of thinking about it. As I said, I think that the utterly forgotten Eritrea-Ethiopia Claims Commission on this point, again, peopled by Hans van Houte, Lucy Reed, John Crook, extremely solid international lawyers with a good sense of how states think about it, ultimately did not decide on the point, but felt very comfortable to explain how they would have approached it, that there could have been a way to ask the question and a way to cap it, albeit possibly it was a slightly peculiar applicable law clause of having directly applicable human rights treaties, which may have played a difference, but in a way they were not hugely concerned that that would be an impossible thing to do. And even the Permanent Court of International Justice in the Sokobel case, which was admittedly a little bit of a peculiar run, but seemed moderately comfortable that they could appoint an expert for assessment of these matters. So I think to the extent that any states at least reflect whether that would be a sensible thing to do anywhere, that would, feel that my work invested in the writing of the paper would not be entirely worthless. Thank you.
Thanks so much. And thanks to all of our panelists, thanks to all in the audience. Thanks for the great comments and questions. I learned an incredible amount and think that this is probably the start of many more discussions on these topics. So, well, not the start, but some way in. So thank you very much and enjoy your days. We'll see you again. Thanks. Bye.